Okay, so today I have Jennifer Zerk with me, and we are going to explore with her the remedy landscape and seek to better understand how companies' grievance mechanisms, often referred to as operational level grievance mechanisms, particularly in the UN Guiding Principles on Business and Human Rights, as a type of non-state-based grievance mechanism, interact with other types of mechanisms. So, for example, state-based judicial mechanisms, non-judicial mechanisms, and I'm going to show here in a second a diagram that maps out that remedy landscape quite nicely. And what we want to know is how these different mechanisms interact in the provision of remedy to victims of corporate human rights abuses. But before we go there, I want to take a moment to introduce Jennifer. So Jennifer works as a freelance consultant in the field of business and human rights, focusing mainly on legal and regulatory issues. She has worked with the Office of the High Commissioner for Human Rights, the OHCHR, as a consultant for many years, and I think many of you will probably know her, principally from the work that she's done on its flagship Accountability and Remedy project. She advises on the business and human rights dimension of other OHCHR work as well, such as the BTEC project and a recent project led by the Disability Rights Team on frameworks for more inclusive and human rights responsive care systems. So thanks so much for being here today, Jennifer. And
Thank you for having me.
yeah, great to be here. And just to set the stage, I'm going to ask a question about, you've been working alongside your colleagues, as we said, on the Accountability and Remedy Project, diving deep into this remedy ecosystem. And there's been some wonderful materials published from you guys. And you've been looking at the multiple ways through which we can ensure that those who experience human rights harms involving economic actors can be made whole again to the extent possible. So I guess my question is, why is access to remedies so central to the purpose of the UN Guiding Principles on Business and Human Rights? As a concept, I think, that cuts across the three pillars. And just to remind folks, the three pillars are the state response, the state duty to protect, the corporate responsibility to respect, and then the third pillar, remedy itself. At the same time, it's often said that the third pillar, the remedy pillar, is the most neglected of those three pillars. So just want to kind of get a sense from you, why is that?
Thank you. And yes, and well done. Thanks for that introduction. Yeah, and thanks for the chance to join you virtually today. Yes, I was closely involved in all of that work. I should make clear, though, before I start, that I'm speaking to you today in my personal capacity, albeit against the background of many years, as you said, of close involvement in the work of the business and human rights team at OHCHR. But to go straight to your question, I see remedy as really crucial. It's really central to the UNGPs because that's the means by which we get good outcomes for people who are affected, which is what we're really about. We can have all of the systems and processes in the world to map risk and gather information, but if we don't respond to what we know in a way that addresses the problems that we see, and which in a way that helps to make people whole again, as you put it, then really, what's the point? What's the point of all of this? So, and we also mustn't lose sight of the fact that the right to an effective remedy is itself a human right. It's a recognized human right in its own right. So a state that's falling down on its ability to ensure that effective remedies are delivered when people's human rights have been breached will be failing its duty to protect. And a company that doesn't work proactively and in good faith towards effective remediation, or maybe even take steps to obstruct this, would be falling down in its in meeting its corporate responsibility to respect. That's the pillar 2 that you mentioned. So access to remedy really does run through the whole of the UNGPs, as you said, and anyone who sees this as kind of confined to the third pillar as some kind of add-on would be really fundamentally misunderstanding the whole vision that underlines the UNGPs. But in terms of your question about whether it is in fact the most neglected of the three pillars, and if so, why? It's kind of hard to say, because I'm sure that there are places and contexts where that's not the case. But my personal feeling is that it's frequently neglected or overlooked because it's quite hard.
Yeah.
It's really, really hard to figure out exactly which actors are responsible for delivering remedy and why in specific cases. It's very context dependent. It's also very hard. It can be very hard, and it's quite often impossible to say in the abstract what an effective remedy would be in different cases. Um, without a very deep understanding of lives and needs and expectations. Um, from the perspective of what states are required to do, it's really hard, and it's getting harder to access and maintain the resources that are really needed to ensure that remediation systems are working well. So it is really hard, and that's why one of the reasons why the Accountability and Remedy Project came into being, and why the OHCHR invested so much in developing the interpretative guide, an interpretative guide on access to remedy, to really help unpack some of that complexity for people who really need to know about this stuff. And also we were hoping to try and show the way to more sort of a more creative, innovative, more kind of problem solving approach to remedy, and also a much more impactful way of doing things. And that, just to sort of pick up on what you said in the introduction, and that can really involve a multiplicity of different actors, state-based and private.
Yeah. And on that note, I'm going to turn here. I'm going to share my screen. You had mentioned the interpretive guide that you had put out with your colleagues, and I wanted to share here for a second when I can find my sharing function. Um, the guide itself, just the cover here for a minute. And I want to focus then to, in particular, a really helpful diagram. Let me just show the cover here for everybody. This is the guide that Jennifer just referred to. It's really detailed and just a wonderful resource, and very well organized in terms of questions that are answered. So I think you can just go look to see maybe questions you already have in your head, and you can find them in the guide and find some really useful answers and links to other resources. But in particular, I want to go down to page 17 of the guide, which has, to my mind, a really useful overview of this remedy landscape. You know, both state-based judicial, non-judicial grievance mechanisms. We're obviously focused today a bit more down the bottom on operational level grievance mechanism as a type of non-state-based grievance mechanism. And what I was really, wanted to ask you, so we just had our fifth webinar of the Corporate Responsibility Respect, the CR2R webinar series, and that's on our website, the recording, as well as some really useful resources and video logs. This will be one of those video logs, so I encourage people to go there. We have a link to this interpretive guide there. But I wanted to maybe ask, could you briefly walk us through this ecosystem and explain a bit how these different types of remediation mechanisms relate to each other? Should we be thinking of this as a hierarchy whereby, for example, some remediation mechanisms are better than others? So maybe potentially those that are state-based and judicial, one thinks of those as having kind of real teeth. And are some better than others in terms of providing victims of human rights arms remedy? Could you maybe comment to that?
Sure, sure. And I'm really glad to hear that you've recently had a webinar on grievance mechanisms as part of your work on Pillar 2. It sounds like there's a lot of resources there that I need to sort of just have a look in case there are some interesting takeaways that
A lot from you.
that we can use. Thank you. Yes, of course, I recognize this table. And again, yes, it is quite helpful as a way of demonstrating the point that we were talking about just now about the remedy theme running through the whole of the UNGP's three-pillar structure. So we start with the agencies that the states have responsibilities for, and we try to draw a conceptual distinction between courts, which are operated out of the judicial branch of government, and other kinds of state-based bodies that you tend to find more closely linked to the executive branch of government. That's the middle lot there, and these can take the form of regulators and ombuds, as is marked there, and various kinds of government initiatives. They frequently operate subject to a regulatory mandate, and they may have been given statutory powers and resources. Well, and hopefully they've been given sufficient statutory powers and resources to do their job properly. Then at the bottom, you see the kinds of mechanisms that you would have been discussing at your webinar, I expect. And I distinguish these from the other ones that I've just mentioned by pointing out that these are not official in the sense that they're run by states, rather they're privately operated. So that's the basic typology. Now, a lot of people think that, and I would agree to some extent, that the regional and international human rights bodies look a little bit odd there, being placed in the same box as the company-based ones. The reason for that is explained in the UNGPs and also in our interpretative guide. They don't quite fit in the state-based groupings because they function separately from state processes under their own sort of intergovernmental arrangements. So if you consult the UNGPs, you'll find them grouped together with other kinds of mechanisms that states don't really control on a day-to-day basis. So we've kept that conceptualization here. But the answer to go to your question about how they kind of how they relate to each other, this can, or how they can interplay, this can be quite complex in practice. And as part of the second and third phases of our work on the accountability and remedy project, we put a lot of effort into trying to understand how these relationships work in practice, how they might interact, and whether those relationships and how well they function might have a bearing on how well and how easily effective remedies can be delivered to people. But it's a bit difficult to generalize. So I was just wondering if perhaps a few examples of common interplays might
Absolutely.
might help to explain. Okay, so and here's a common example for you. I'll call this example one. It's quite common for a regulatory regime to specify that grievance mechanisms must be provided at company level. So the obligation to have a grievance mechanism at company level then becomes the kind of regulatory responsibilities of a company, which then is subject to, you know, regulatory oversight. So when this happens, it could be that if a company-based grievance mechanism isn't working so well, this could form the basis of a complaint to the regulator under its own complaints apparatus. You see this kind of set up in the EU legislation, corporate sustainability legislation. Or things could also be set up so that people can have a right of appeal from a company-based scheme to a regulator. Okay, so then that's an example of an interplay between the bottom one and the middle one. A second example might be if a regulator were to uncover some form of human rights abuse that's punishable through the criminal system. So you may see a referral from a regulatory investigation to criminal law enforcement. And if that happens, you then have an interplay between the middle ones and the top one and the court one. So you might see there might be opportunities, for example, to call the regulator or representatives of the regulator to give evidence in a court process. Okay. And third example could be a negligence type case. And in a negligence type case, which would be running through the court system, the top ones there, it's possible that a court might want to examine the quality of the company's approach to risk management, which might include the quality of an operational, grievance mechanism to see how well it's picking up on risks and whether the relevant standard of care was met. So that's an example of how a court, in top one might take a look at what's going on, at company level, the bottom one. So again, interplay between different categories. You can see from that those three examples that the remedy ecosystem can be quite complex and also dynamic, and that's before you even start to factor in, all the cross-border issues that might be in play. But I think you also asked a question about whether there was a hierarchy or whether we should see this as a kind of hierarchy. We don't see it that way, and I hope that the layering in this particular slide doesn't give the impression that there is in fact a hierarchy with the courts at the top,
Right.
because they're most important,
Yeah.
and companies.
Yeah. I think more this idea that something has teeth,
Yeah,
because there's some kind of force of law behind it versus something that's
yeah.
more voluntary in nature, not the diagram
Yeah,
itself.
exactly.
Yeah.
Exactly. And a lot of people will make that argument. But I mean, we prefer to approach this from the perspective of what works in a particular
Mm,
case. So if a company-based system offers a quicker and surer route to an effective remedy than a court process, or might be, more trusted for whatever reason, then that's all well and good, as far as we're concerned. Of course, there may be cases, let's say at the more serious and complex end, where really the only hope of an effective remedy is a route that offers the possibility of criminal investigation and sanction.
mm,
And in that kind of case, courts obviously have an incredibly important role to play, not because they are inherently better or more important for, for delivering remedies as a matter of principle, but rather because a specific case demands a judicial response.
hmm.
So it's very much like the saying here, horses for courses.
Right.
It's whatever works best. So I wouldn't be thinking of these as forming part of a hierarchy as an abstract proposition, rather that these are important actors in a really complex and dynamic
Mm.
ecosystem.
Would you mind if I follow up with the question I was meant to ask later, but I think would fit now?
Sure.
And namely, that question is, I think investors in particular, when engaging with companies and having dialogues, have found that companies often don't want to share details
Yeah.
with those investors or other stakeholders for that matter about how they're addressing grievances when judicial proceedings of some sort or another, so under that first, box
Mm,
there,
mm,
are
mm,
underway. Um,
mm.
do operational level grievance mechanisms become moot in the face of some kind of ongoing judicial proceeding?
Yeah. Sorry, when I say yeah, I mean yes, I understand the question, not
Question, yes,
yes.
no, I get
Not
it, no.
not that yes is the answer.
Right.
Um, no, I'm basically saying that yes, I understand where this is coming from. As a former corporate lawyer, I do understand the sensitivities here. And actually, just taking one step back, when we were working on the accountability and remedy project, we did hear a lot of concerns from companies about things like how operational level processes might be used as fishing
Hmm.
expeditions for subsequent litigation, or that a company might go to a huge amount of trouble to agree a remediation package with affected people, but then be faced with litigation anyway, arising out of the same fact situation,
Hmm.
perhaps involving a different set of complainants, which makes things even more complicated. So there are difficulties getting to legal closure. Um, there are also concerns that certain elements of a remediation package might also have a prejudicial effect if there was a subsequent legal case.
Hmm.
But despite that, all those complexities and challenges, I would very vehemently disagree with the idea that operational grievance mechanisms are moot because there are judicial proceedings in place. Um, because if there are groups of people wishing to explore solutions through dialogue, facilitated through a company-based system, it's really important from an access to remedy perspective that this is not closed down to them. Um, and in our interpretative guide, we really push back against the idea that pursuing things in parallel, for example, at the same time through a grievance mechanism and in the courts, should be regarded in any way as any kind of like gamesmanship or
Hmm.
opportunism. And this is because affected people often need to draw from a range of different remediation options, particularly in complex cases, in order to stitch together something that approximates an effective remedy that gets them to where they need to be. And we did quite a bit of empirical research for the second phase, which really bears this out, that people are sort of mixing and matching quite
Hmm.
often in different cases in quite complex and quite interesting and creative ways. So, in complex cases, it's quite likely that complainants will be wanting to pursue a range of legal and communications and engagement strategies at the same time, and not to get an advantage but simply to get an approximation of a remedy at the end.
Yeah.
So I think that's how we would
Point
view
taken.
things.
And I'm just
Yeah.
going to point folks, there's a really great box, the kind of a sidebar in the guidance here. It talks about that, parallel proceedings and not viewing it as gamesmanship. And I just maybe one other point too, I think is important is that, even if there are other types of proceedings going on, the operational level grievance mechanisms also remain important for the company itself to use the lessons from those processes to improve its own risk management system, due diligence processes, so that that's always remains an important thing.
Yeah. Yeah.
Maybe I'm going to stop sharing here for a second and encourage people though to look at this guidance. And as I said, it's linked on our website. But I want to talk for a moment about what kind of enabling role that states can play in terms of focusing now to operational level grievance mechanisms. What can they do to try to help companies ensure that those really are effective mechanisms that can offer effective remedial outcomes?
Sure. And thanks for asking that question, because we've recently been doing some really interesting work on this in the context of the project that you mentioned at the start, that's being run by the disability rights team. I mean, basically, states play an absolutely key role here. And if people watching or listening to this want to explore a really interesting case study about how this works in practice in a specific sector at quite a granular level, then please do look out for the series of papers that the OHCHR disability rights team have put out today, this morning,
Oh,
in
really?
fact.
Okay.
Yes,
All right. We'll
yes.
have
So
to find that
you're
link.
some of the first people to hear
Hot off
about
the
this.
presses.
Hot off the press. And those papers are about the care and support system and how we move to a much more rights respecting care and support systems. So the role of states can be a legislative one, of course, and we point out in the interpretative guide the importance of paying attention also not just to the big, the big flagship regulatory systems, but also those regimes that kind of hum along in the background, such as freedom of information, whistleblower protection, labour rights protections and guarantees. They may not explicitly reference business and human rights, but they can have a really profound influence on the ability and willingness of people to trust company-based mechanisms in practice. So so there's that sort of legislative piece. There are also other activities that states can get involved in, such as awareness raising, capacity building, investing in excellence and knowledge exchange hubs, so many different things that states can do to support. And the disability rights team papers, I think it's the first one that looks specifically at the role of the state, also looks at the role of the state as a market actor, because in that sector, of course, states are commissioning services.
Right.
There are so many lessons from that work, such as making the most of opportunities, the various opportunities that come up to incentivize good practice through the public procurement system. And I think there's a lot of lessons actually in that paper which could have wider, broader relevance.
Thank you. And we'll be sure to take a look at those papers.
Yes, please do. Please do.
So I'm going to slightly switch gears a bit. This is not in any way meant to be a trick question, but I guess what I want to ask is access to remedy the same thing as corporate accountability for business-related human rights harms? I think remedy, as we just said, we think of those who've been harmed, making them whole again, if all possible. I think when we hear the word accountability, frankly, I think a bit of like punishment, holding someone responsible, making them take on that responsibility. So are those the same things?
That is it's a really good question, and it's one that we got asked so much because of the title. We called ourselves Accountability and Remedy Project. So people would say, well, is that two things or one? The answer is they're not exactly the same. It's quite difficult to untangle these concepts in practice because they do overlap. But if you look in our interpretative guide, you'll see that we have actually made a valiant attempt to try and explain all this and to unpack all this. I mean, the way that we understand it is, access to remedy refers to how easy or difficult it is for a person to access the processes, both the processes through which they can get a remedy and also the ease with which they can obtain an outcome that they feel does the job that's needed. Okay, so that's the access to remedy part. And accountability, on the other hand, refers, yes, you mentioned punishment. It's kind of a broader kind of sense of taking responsibility, which can be achieved
Mhm.
in a variety of ways, perhaps through making an apology or paying a fine to the state or some kind of corrective action. But it's a taking of responsibility, and also the things around that help to signify that. The two concepts have obvious overlaps though, because in many cases the accountability part is a crucial part of an effective remedy. People who've been affected want to see some accountability, and in turn the delivery of an effective remedy can be a really important part of achieving accountability, of showing that you
Good.
take responsibility. But we also note, I think, when we were putting the interpretative guide together, that accountability sometimes extends beyond accountability to a specific person, the specific person whose rights have been abused, to more society as a whole. So to encompass accountability to the whole of society. So a monetary fine could be important for achieving this broader accountability. You pay a fine to
Mhm.
society. But this doesn't necessarily amount to an effective remedy in a specific case, as many people will say, especially if there's, a call for some kind of financial compensation to be paid. So you might have a system where there is some accountability, but perhaps not an effective remedy. So we look at this from a sort of, what is an effective remedy perspective, but it's quite complex, sort of discussing the two together. I hope
Yeah.
that makes sense.
No,
I think
absolutely. I
the
think that's
best,
really good to see that interlinkage. Yeah, that
yeah,
was well
they are
captured.
interlinked, and I think the best
Mhm.
way of thinking about this is to be aware that the concepts overlap, but the correlation isn't necessarily quite perfect.
Right. Yeah.
Mm.
Actually, I'm going to jump ahead and ask a question because you just talked about kind of the various ways taking responsibility, how it could look like. It could be an apology, it could be a fine, it could be some kind of, remediation. Can you just briefly, because I think we oftentimes we think of remedy, many of us think of financial, something that's,
Yeah.
going to make whole via monies, frankly. What other kinds of remedies are available through operation level grievance mechanisms?
Well, it kind of depends on the circumstances, um, and the relationships, and what a company can do in a particular case. We we have noted that these kinds of these operational level mechanisms can be particularly good for reaching and working out a plan for delivering a very bespoke
Hmm.
agreed solution over time, perhaps a corrective or improvement program or some kind of monitoring system. They can also perhaps offer a framework for delivering some form of financial compensation and making sure it's targeted to where it's most needed. So the sky's the limit, really. Although go back to the point that I made earlier, that these kinds of mechanisms may not be able to deliver everything that's needed by way of remedy in every case, and there can be legal constraints or practical ones. And of course, as we referenced earlier, anything requiring formal legal enforcement or legal guarantees would need some kind of judicial involvement or oversight. But there's also a further point about remedy that I don't think I've stressed sufficiently yet, and which OHCHR colleagues would very much want me to stress, because it's so important to make, and that's around the question of who decides whether a remedy
Mm,
is effective or not.
right.
Um, uh, our view is that the most important voices in any discussion about what remedy to give and how are the affected people themselves. And I say this because we do often see things offered to people or imposed on them without a great deal of meaningful consultation. I recall one particular consultation back, it was about 6 or 7 years ago, where people lined up to give us examples of really hopeless remedies that were never going to deliver what was actually needed, but which companies at the time thought was a very good idea. And what was lacking in every single case was a sitting down with people who are affected and talking through what would work and what wouldn't. The reality is that the people in the front line are it's when they are the most involved in decision making, you're more likely to get a sustainable solution that actually works. And sometimes also that spark of inspiration, that kind of like,
Mm.
oh, of course, yeah, aha,
Right,
that we
yeah.
wouldn't think of on our own. And this is way more likely to come from proactive engagement with people rather than a sort of closed company knows best kind of system.
And I think that's something that comes out in the interpretive guide is that, in many ways, a strength of operational level grievance mechanisms was, when done well, is that they are dialogue based and really based on that kind of meaningful engagement and exchange with those who are impacted.
Exactly, yeah.
That's actually a very good segue to my last question.
Mm-hmm.
When we had put that remedy landscape diagram up before, there was UN Guiding Principle 31 that listed those criteria of effective grievance mechanisms to include, operational ones with that element of the importance of dialogue. I was wondering, I know that's a lot. I'm not going to ask you to summarize all of those. That's quite a bit. But maybe just for our investor audience in particular that are engaging with companies on their grievance mechanisms, are there some particular hallmarks of one, obviously being this, meaningful stakeholder engagement, that you think that they should look for when talking to companies? Like, what do they really want to push a little bit? Like, what's very important in terms of ensuring that company mechanism is indeed effective and can deliver the desired outcomes?
Yeah, okay. Okay, yes, I won't go over all the guidance that we've done on the effectiveness criteria because there is a
That'd be a
lot.
lot.
There is
Yeah.
a lot on
And we have
online.
links to those on the website. So
So yes, I mean, there are three things that I think investors should be paying particular attention to. And this is not to sort of minimize the importance of all of the others, but I think these are the what I like to what I would think of as the canaries in the coal mine. So basically, if you can see that there's attention being paid to these, then you have a reason that you can feel more confident that the company's on the right track. And they are, the first one is, as I was saying, stakeholder voice.
Mhm.
Ensuring that there are processes for meaningful consultation with affected people about what they need, so that they can, not so that they can raise concerns properly, but also that there is meaningful consultation about what to do about them. As a side note, actually, it's maybe worth mentioning the increasing use of technologies to do this kind of thing. And we do have a specific work stream exploring the human rights implications of that, because that's a really interesting trend. It's basically, the use of technologies to hear from more stakeholders more often, and to increase reach. It's very exciting, but there's also quite a lot of things to be cautious of. But stakeholder voice is the first one. The second one is making sure that there are adequate safeguards against the risks of reprisals and retaliation. The risks of reprisals or feeling that you're going to have action taken against you because you raise a grievance is such a massive barrier to being able to use these mechanisms in the way they're intended. So that's one, serious safeguards. We recommend in the third phase, the guidance that we've put together, that there would be some kind of risk assessment process, to really get to the bottom of what those risks are and how to head them off. And the third one is systems for gathering lessons learned to ensure that problems and abuses are not repeated, and that opportunities for achieving, more fundamental and even perhaps systemic change are recognised
Mm.
and acted upon. So those would be my three,
Yeah.
three sort of headlines: stakeholder voice, safeguards against risks of reprisals, and systems for gathering lessons learned.
Yeah. The
If you,
latter, moving away from the reactive to really trying to be
yeah,
proactive.
yeah,
And yeah, I
exactly,
like that.
exactly,
Yeah.
exactly. If you find problems with any of those, then there are likely to be problems elsewhere. But if you if you can see a company performing well in those, then you can see, that there's a mindset there that that the company understands these issues and is taking them seriously. Actually, while I think of it, these papers on the care sector, which are coming out today, do contain some explicit advice on things that investors should be looking out for, particularly around the business models of care and support services providers, that will help to provide an indication of the human rights challenges which human rights challenges can be fairly easily rectified, and which, including through better stakeholder engagement, and which are perhaps more embedded in, problems in the way, the services are being conceptualized and rolled out. So yeah.
If you'd be willing to share the link to those new papers, I will gladly share those out along with this video that we've
I
seen.
absolutely can after
All
this
right.
after this call. I will absolutely do that.
Fantastic.
Yeah.
So then those were my questions. I want to thank you again, but first I want to ask, is there any other type of closing comments or something you wanted to say that we maybe didn't cover today?
No, just to be aware that there are a lot of really useful resources on the OHCHR Accountability and Remedy Project website, including these new practical guides as well. Can you see those? Yeah.
Yes. Excellent.
This is
Excellent.
basically a user-friendly version of the of all the findings from the various phases of the Accountability and Remedy
And
Project.
actually, that one, I do remember now, we have put that on the website as well.
Great.
So
Okay.
we have a link, and that's a bit more condensed, perhaps. But I still encourage folks to look at the interpretive guide, because you can really dive in via those questions to particular areas that may be of interest or important to you. So
that's
fantastic.
absolutely the hope. Yeah. Yeah.
Well, thank you again, Jennifer. We really appreciate it. I have no doubt this is going to be of interest to quite a few of our investor members. So thank you so much for taking the time today.
Thank you for having me.
Great.